us for the next hour is Irwin Aronson, labor and employment attorney at Willig, Williams & Davidson, and Alex Halper, Director of Government Affairs of the Pennsylvania Chamber of Business and Industry. There's a bill before the State House that would eliminate an exemption in the Pennsylvania Crimes Code in the context of labor disputes. Representative Ron Miller was in PCN's studio recently. Let's listen to his explanation of his bill.
Under the law, it's illegal for you, me, anybody out there to harass or stalk someone. And if you do that, you can be charged with a violation of the Crimes Code and go to court and be convicted. It also applies to the threatening to use weapons of mass destruction. But for some reason in the past, we had exemptions put in here for the people that are involved in a labor dispute, dealing with management and unions, so that if you are part of a labor dispute, you can harass someone and not be charged with harassment. You can stalk someone and not be charged with stalking. And what confuses most people the most is you can threaten to use a weapon of mass destruction and not be charged with a crime.
Alex, what are your thoughts on this bill?
Well, when we look at the organized labor community in Pennsylvania, primarily we see unions that work constructively with employers, with their members, with open shop contractors, and of course we see union members that are good people just doing their job, but anyone who's been involved in business in Pennsylvania, and probably anyone really paying attention in Pennsylvania, knows that there's also another side to the organized labor community, and it's an element that uses intimidation and bullying and other tactics, and some of the tactics that Representative Miller referenced, harassment, stalking, bomb threats, to pursue their objectives. And it's in many areas of the state, it's really become just a fact of life for businesses that are trying to operate. So we're pleased that Representative Miller has introduced this bill. We support it. We hope that it brings more attention to some of these bad elements. We think it's unfortunately bringing a bad perspective to the union labor community in Pennsylvania, and we're hopeful that this legislation will be considered by the full House and can progress through the legislative process.
Irwin?
This is just absurd. This is a solution in search of a problem. I'm pleased that my distinguished colleague has found it in his heart to say that he actually has found some good in some of these union folks in Pennsylvania. Reality is that no law enforcement agency in this state, no attorney general, Democrat or Republican, no district attorney in any one of our 67 counties has called for this radical change in the law. What the law does in its present form, and I note, by the way, that these provisions were adopted by the Pennsylvania General Assembly in 1993 at the insistence predominantly of the Pennsylvania Chamber of Commerce, the predecessor organization for which he works. I'm here today in my capacity as general counsel to the Pennsylvania AFL-CIO. I was in that capacity in 1993 as well when this came up. I have some understanding of the history and development of this statutory framework. Members of the General Assembly, particularly Republican chair of the Senate Judiciary Committee at that point in history, recognized that when we were doing something really wonderful in Pennsylvania by initially adopting an anti-stalking statute to put real and serious teeth in the law as it relates to people who are victimized by stalkers and stalking, needed to also deal with the fact that we have in this country federal labor policy uniformly applied throughout the 50 states. And federal labor policy protects certain kinds of conduct. It is protected speech, it is protected conduct. And in our relationship of federal-state relations, where the federal government has enacted legislation or regulated an area of the law, they're said to have occupied the field. occupying the field means that no individual state can do otherwise. So the Pennsylvania General Assembly in 1993, in adopting the anti-stalking statute, with the encouragement of the Pennsylvania Chamber of Business and Industry, previously known as the Pennsylvania Chamber of Commerce, adopted amendments to what was then being considered by the General Assembly aimed at assuring the protection of that federally protected conduct. Now you may ask the other question as to why that conduct should be entitled to certain federal protections. Recognize that those of us who are privileged to represent working men and women in this state, the Pennsylvania AFL-CIO and its affiliates, who represent some 800,000 roughly working men and women in this state and their families, abhor violence of any sort or kind. We abhor it if it is attributed to us. We abhor the violence that is perpetrated upon us by employers every day as we attempt to exercise those federally protected rights. But what is really critical, and what is the essence of all of this, is that the federal statutory and regulatory framework with respect to labor management relations in this country is based upon and imbued with the notion of strict neutrality of government agencies in the private process of labor management relations. Indeed, going back to 1935 with the passage of the Wagner Act, also known as the National Labor Relations Act, 78 years ago, the notion was to establish what the framers of that law called laboratory conditions, that the government would not fall on the side of any of the participants in the process. Now, with the amendments adopted as they were in 1993, that assures that nobody will create ancillary or side issues by creating specious prosecutions of federally protected conduct, constitutionally protected conduct. And if we repeal those, as is suggested by Representative Miller and his legislation, what we will do is create a sideshow. We will eliminate that neutrality. We will destroy those laboratory conditions. And instead, what we will find is that instead of sitting down at a table, labor and management working together, we will have this sideshow. And recognize as well that if we have the sideshow begin, we have 67 counties in Pennsylvania, which means we have 67 district attorneys in Pennsylvania and 67 courts of common pleas in Pennsylvania. The result, of course, will be that there will be 67 different interpretations of what that law means, and instead of the federal uniformity that we desire and have desired for 78 years in this country under the National Labor Relations Law, we will have some chaos. And that chaos is of no value to anybody, labor or management. And we also need to recognize one other thing. The law in its present state is not aimed at protecting, as Representative Miller implied, union conduct. It's aimed at protecting all conduct in the labor management relations process. I dare say that employers and employer representatives, in some limited instances, but unfortunately more frequently than we like, are engaged in conduct that would no longer be protected. If I were an employer in Pennsylvania at that level, I'd be very worried about the potential that this legislation, if adopted, would restrict my right to call my employees, to discourage them from joining a union, to visit their homes, to inquire of their activities. But if this protection from 1993 were to be repealed, as Representative Miller suggests, that's precisely what would happen. That laboratory condition would be destroyed, and there will be district attorneys who have a need, political or otherwise, to chase people, whether they are union activists and working people or employer activists who are engaged in trying to do something that would result in a union being kept out or decertified or destroyed.
Welcome to the PCN Call-in program. I'm Corinna Wilson. For the next hour, our guests will be taking your calls about labor activism and the Pennsylvania Crimes Code. Our toll-free number is 1-877-PA6-5001, You may begin dialing now. Alex, I know you'd like to respond.
Well, as I said at the onset, we know that most unions are not engaged in these activities. And so I think the issues that we're talking about this evening and this legislation does not apply, would not impact to the vast majority of unions and union members that are doing their job, doing it responsibly. But as anyone knows, that does not represent the entirety of the labor community in Pennsylvania. The House Judiciary Committee held a hearing back in August of this year where you had several businesses come and testify to give their experiences, and some of the stories they had to tell were really really horrific. People being followed home from work, not just the owners of the business, but employees from the business. There's an apartment complex construction company in Pennsylvania where they've been a target of a campaign of harassment that's been extremely aggressive, and they've had the residents of their apartments subject to this kind of behavior, and you sort of go on, and this is nothing new. This is not groundbreaking news that I'm talking about here. This is something that, in particular, in certain areas of the state, this happens all the time, and it's a way of life. Now, I was not here in 1993 when these amendments were added, but I cannot imagine that legislators working on legislation back in 1993 had contemplated and decided to sanction the type of behavior and the type of activity that we see happening right now around Pennsylvania, but in particular in certain areas. Irwin referenced federal laws, certainly the Constitution, but there are federal laws and state laws that are in place that specifically protect the rights of unions and union members to protest, to picket, to do anything that would be considered protected activity and constitutional. Certainly, we would not think to try to impact those rights. But when you're talking about following people home, you're talking about following some of these employees to their kids' sporting events, or posting signs throughout the entire neighborhood of where someone lives. You can't tell me that in 1993 they were imagining these scenarios and saying, yeah, let's exempt these parties from any kind of prosecution for harassment, stalking, or bomb threats. So the current system simply isn't working. We have businesses in Pennsylvania. It's not just businesses. It's employees of open shop contractors. Who are being subject, who are being victimized, who are being bullied and intimidated. The system right now is not working for those individuals, and while we don't, Representative Miller's legislation, we think is an important start. It's an important piece to addressing this problem. It doesn't. I don't think it's a silver bullet to take care of this, clearly irresponsible, illegal activity, but it's certainly a start. And I would mention, Pennsylvania, I think, is only one of a handful of states that specifically exempt parties to a labor dispute from prosecution for these crimes. So there are better ways to do it than what we have right now in Pennsylvania.
Well, unfortunately, despite Alex's protestations, what that hearing that he referred to, that the House of Representatives Judiciary Committee had demonstrated, among other things, that it was not one witness who appeared could articulate even one instance where this radical change in the law would have changed anything. People who break the law, who commit crimes, who engage in this, what I to this point have known only as hyperbolic claims of use of weapons of mass destruction, or pedophilia was another claim, are today subject to prosecution in Pennsylvania. That is the law. As a 30-plus year member of the bar of the Supreme Court of this Commonwealth, I can assure you that that is and has been continuously the law. What we did learn, however, at that hearing was that unlike days past, when the Judiciary Committee, for example, would have a public hearing and every witness had to raise their right hand and swear to tell the truth before they testified before that committee, not one witness at that hearing was sworn to tell the truth before they put on their hyperbolic show and told these putative stories, most of which have already been debunked, and all of which are at least subject to the question of why they didn't swear to tell the truth before they told their stories to the House Judiciary Committee, the People's House.
Is it
Judiciary
still common
Committee.
practice in legislative hearings for witnesses to be sworn in?
No, that was eliminated a couple of years ago, and we don't know why.
Let's take a call. Frank from Ben Salem, you're on the air.
Thanks for taking my call. Yeah, I saw those hearings, and I saw the Post Brother things and that. I was wondering why the ABC let out the guys getting. There was no union arrest for, I think, a year of protesting down there. No one from any unions were arrested, but there were two guys arrested, and they were part of a motorcycle gang that employer Post Brothers hired to go in there, and I think the one guy got a broken collarbone out of it and all like that. Why wasn't that omitted in the testimony there? And the other guy that was at the hearing saying about he was getting harassed with the hand flyers, they were all comical. Isn't that protected under the First Amendment, freedom of speech? I mean, I live in a neighborhood. I'm a working class guy. I see people put up signs all over the neighborhood, yard sale and all like that. Campaigning, you go right out the door today, you'll see all these signs all over the place. Vote for this guy's running for recorder of deeds. But if an employer does something wrong, they can't be publicized about that. I mean, what about the employer that threatens the employee? Because I came through an organizing drive, threatened at work, discharged at work, found out that the employer illegally fired me out of work for 3 months before it got resolved, possibly almost lost my house, income, and everything like that. Isn't that harassment? Isn't that coercion? Isn't that illegal? Shouldn't that be considered illegal? Because under the NLRA, that's protected. It's not protected activity, but it's not criminal activity.
You know, I think anyone who commits a crime should be prosecuted for it. The current exemption applies, as Representative Miller very clearly said. The exemption applies to either party to a labor dispute, management or labor. And I don't think an employer should be able to harass and stalk and make bomb threats with impunity. If you commit a crime, I think you should be, that law enforcement, prosecutors ought to have every tool at their disposal to prosecute that crime. I guess we can, if you want to just assume that the testifiers at the hearing were making it up and were lying, that makes it easy. But there were pictures. You had individuals. There were videos. You had individuals giving accounts of their experiences when they, and the Post Brothers is a good example. Here's a company in Philadelphia who had the gall to not agree to exclusively 100% only hire union.
The Post Brothers story. That's not the factual story. That's the problem.
Union labor they had a combination of union and non-union labor that they had decided to hire for a particular project. When the first non-union contractor was hired, all the unions pulled out from the project. All those workers had to stop working, had to stop earning their salary, and started this campaign of protests and pickets, all of which is protected. It's when it crosses the line to harassment. And I think we have to give our law enforcement, our prosecutors, the discretion. We know that crimes like harassment and stalking, these are not clear-cut crimes with very specific qualifications for when someone gets prosecuted. They spell it out as best as they can in the law, but we depend on our law enforcement and our prosecutors and our judicial system to look at a situation, to look at a context and say, does this constitute harassment, yes or no? The caller referenced the other situation where signs were being posted. Sure, you're allowed to post political signs, but these were not comical signs. These were pictures of a business owner, pictures of his wife in inappropriate inappropriate pictures.
We do not know today any better than we do the day that they testified before that committee who placed those signs.
That is absolutely untrue.
But we do know that the Post brothers had a multiplicity of charges against them.
If I may, okay.
You may, but you're dominating this, and let's respond. Let's take this apart. Let's piece this. What we do know is that no witness was sworn. What we do know is that these were a series of allegations. What we do know is that true criminal conduct is prosecutable now, and what we do know is that no one in that situation, other than a couple of motorcycle gangbangers, have been prosecuted for anything because they haven't violated the law. This is not criminal conduct. It may not be the most pleasant thing for the person who is the subject of it, if it is indeed happening. But I don't know, as I sit here, whether the Post brothers planted signs or whether some people acting outside of the ambit of the authority of a union were doing this. I don't know any of that, and if the witnesses had been sworn, I might be able to have known that. They may have been subject to the normal rules of evidence. I don't know who doctored what photographs. I don't know who fiddled with what videos. I don't know, and none of that would stand up in a courtroom, which is my playground, ever.
With all due respect, I don't want an attorney for the AFL-CIO deciding what's criminal conduct. I want law enforcement, I want prosecutors, and I want the judicial system to look at a situation and let them determine what's criminal conduct.
And I would only
spend one at a time.
And just to address one thing you mentioned, the signs that were posted. This is not Philadelphia. This is a situation up in Berks County. This is not just a Philly problem. This is statewide. Those signs, the unions who were perpetrating this activity clearly identified who they were. And if law enforcement had the ability, if they looked at this situation where signs were being put in cars and in the doors, 150 houses within this individual's neighborhood, if they decided that, yeah, this crosses the line, that there's free speech, and then you cross the line into harassment or some kind of other criminal activity, they ought to have the ability to say, no, this is inappropriate. You're allowed to speak your mind. You're allowed to disagree over hiring decisions, over wages, over work conditions, but you're not allowed to harass.
And indeed, at the hearing, at the House Judiciary Committee hearing, one of the members of the Judiciary Committee, Representative Dom Costa from Allegheny County, who had a career as a law enforcement official prior to becoming a member of the General Assembly, asked these very questions, and Representative Costa ultimately indicated, from his view as a professional law enforcement official, that none of the claimed conduct that Alex speaks of was the kind of conduct that couldn't be prosecuted simply because of these statutory protections that the General Assembly adopted. What we do know beyond peradventure, is that there is violence that takes place at the workplace every day. If we want to talk about a true weapon of mass destruction, when people lose their jobs and as a result lose their homes, lose their cars, lose their utilities because they get fired as a result of having the temerity to suggest that they might want to join a union, that is truly a weapon of mass destruction. It destroys families. It destroys that laboratory condition of which I spoke a few minutes ago in the labor management relations context. What we really need to deal with is the very narrowly defined scope of what a labor dispute is, not what Alex or you or I think a labor dispute is, but what a law referenced in that 1993 statute says, going back to 1937, is a labor dispute. And it's narrowly defined, and it has to do with those issues only and nothing more.
And we'll get back to that, and also this issue of preemption. But let's head back to the phones. Carl from Allentown, welcome.
Yes, how you doing? Yes, my name is Carl Simmons. And I got a situation. I have bipolar disorder, schizophrenia, and what it is that I filed an ADA claim against 3 agencies. That's EOC of New York, EOC of Philadelphia, and the Human Rights State Division. Now, the sad thing is about it, when I filed my claim, they wound up filing an old court summary that a judge closed years ago.
I'm not sure that's relevant to tonight's discussion, but Carl, perhaps you could call back another night when we have some professionals who could answer your questions. I guess, Irwin, you raised this issue of preemption, that the federal laws governing the labor relations in this country preempt states from enacting laws that would conflict with those schemes. So I guess the question is, if this House Bill 1154 passes, what's the practical result? Would the doctrine of preemption come into play, and would this just have to get litigated out?
Well, the doctrine of preemption would come into play, but the way that we reach those conclusions, absent a statutory framework that levels the playing field, as the current anti-stalking statutes do, is through protracted litigation. And it is obviously time-consuming, it is obviously expensive, but most significantly, while it is going on, two things are happening. One is that the intended federal framework for labor management relations to go forward is compromised. We have this sideshow going on. I'm not going to sit down at the table with you until this alleged criminal matter is resolved. You're not going to sit down at the table with me because you're prosecuting me in state court. And how can I possibly trust you on that? The second thing that's going on that is much more troublesome for everybody involved is that because we have 67 counties, and 67 elected prosecutors, and 67 courts of common pleas, some of which, well, not exactly 67, some counties are merged, but we have 67 courts that govern these kinds of things. With different jurists, with different experiences in different communities, we will have a hodgepodge of interpretations that will force us to deal not only with the federal preemption issues, but also with appellate practice at the state level of appeals to either Superior or Commonwealth Court, depending upon how that plays out, and ultimately to our Supreme Court, all of which are happening as an alternative to and an impediment to the natural process of labor management relations in those strictly neutral laboratory conditions that were contemplated by the founders and the framers of the National Labor Relations Act in the 1930s. Remember, of course, that unlike any other institution in American society, unlike any business, unlike any trade association, unlike any typical nonprofit, unions are very heavily regulated under another federal law, the Landrum-Griffin Act that was passed in 1959, that not only confers upon every single union member specialized rights, the Workers' Bill of Rights, the Union Members' Bill of Rights found in the Landrum-Griffin Act, but even employers with whom we have a relationship, employers with whom we'd like to have a relationship, employers who are absolutely opposing us, have the right 24 hours a day, 7 days a week to get on the internet and see our books and financial records. They're public. No business can say that. Imagine if we had had a similar regulatory framework applying to businesses or maybe even banks a few years ago as the economy was being twisted and turned down the drain, as our pensions were destroyed, as public finance was wrecked. We have that, and the labor movement and unions throughout this country, and indeed here in Pennsylvania, have lived with that and subscribed to it and elevate it and truly worship it, and have done so since 1959. We have nothing to hide. We don't know, for example, what employers spend on union baiting, union busting campaigns in this state, but everybody can find out what unions spend on organizing efforts in this state. Not a big deal. Not anything that we have to hide. That's real world. That's our reality. And it is in this framework that people like me get a little bit weary when we hear, well, everybody knows that most of the unions are good, but some of them aren't. Okay? Unions do not authorize. Unions do not engage in, as an institution, untoward conduct or criminal conduct. It may be that some of the things that we do in our effort to organize people or help them make a choice about whether or not they would like to be protected and participate in a union of their own are not particularly loved by employers. But we need to recognize that that National Labor Relations Act, to which I've referred now several times tonight, doesn't contain a section, doesn't contain a paragraph, doesn't contain a sentence, doesn't contain a phrase, doesn't contain a word that confers any rights upon employers. It's about workers having the right to freely choose whether or not they want to be represented by a union. The only employer rights in that statutory framework and the regulations supporting it are created by judges and jurists and labor board decisions that are interpreting that law. The law never contemplated employer participation.
See, I don't, this issue has become a, management versus labor, just another labor issue, and I don't see it that way. I think this is a law enforcement issue. When you have a labor issue, you have people on one side that say, oh, all the labor unions are terrible, and then you have people on the other side that say, all the labor unions, they're all Boy Scouts, they're all just trying to take on the bad employers. Obviously, the reality is somewhere in the middle. Like I said at the beginning, like I continue to say, most unions and most union members are not engaging in these behaviors. But we all know that some of them are. And the vast majority of other states in the country, certainly there are federal laws at play. There are federal protections that ensure that activities of unions that are protected under the National Labor Relations Act can continue to happen. But the vast majority of other states in the country haven't gone and said, well, when you cross that line into harassment or stalking or making a bomb threat, you need to have a specific protection, parties to a labor dispute, so that law enforcement and prosecutors cannot go after you for that. And anyone else, as Representative Miller at the beginning of the program stated it clearly, anyone else can be prosecuted for harassment, stalking, and bomb threats in virtually any other situation. And yes, in 67 different counties, there are different interpretations, and that's kind of the point of it. As I said, harassment, it does have when you try to define harassment, there is a gray area. We are depending upon our law enforcement and our judiciary to use their experience, use their instincts to know when something crosses the line into a crime. So I think I think talking about the federal or state laws that protect these activities and concern over preemption, concern over how 67 counties or different judges might interpret a change in the law. You can say that about any law. You can say that about the current statute, the current crimes code definitions for harassment and stalking. Bomb threats are a little more clearly defined, but that should not be an excuse for not taking up this legislation, because that applies to harassment, stalking. That applies to any crime. We are depending on our law enforcement and our judiciary to enact these laws.
Let's give our guests a short break while we look at some upcoming programming here on PCN. Coming up next on the issues with Chief Justice of the Pennsylvania Supreme Court, Ronald Castile. He's standing for retention in next month's election. Watch tonight at 8 o'clock. On next week's call-in program, we'll talk about state pensions with David Philman of AFSCME Council 13 and Richard Dreyfuss of the Commonwealth Foundation. That's Monday live at 7 p.m. Don't miss PCN's high school football game of the week this Friday with Jim Thorpe at Lehighton, courtesy of Blue Ridge Lehighton. The action starts live at 7 p.m. Remember, you can like us on Facebook and follow us on Twitter for information on all of your favorite PCN programs and to tell us what you think. Finally, if you like the programming that you see on PCN, please thank your local cable provider. They carry PCN on their channel lineup as a public service. We receive no state or federal tax dollars. I also want to tell the viewers that if they're interested in seeing the whole interview with Representative Ron Miller, that will air election night on November 5th at 8 p.m. Let's head back to the phones. We have Michael from Harleysville. Welcome.
Hello.
Go ahead, please.
How you doing? My statement was just basically, I think that the last thing that we need to do is limit the unions, any type of law that we have. Due to the Federal RICO Act, Most businesses will not be able to run successfully if they had infringements and things that the union have been placed upon them because of things happening many, many years in the past. The union stands for the people. The unions are not going out. They keep making it thing like that. The union officials or people are going out with the bomb threats. I don't know that there is a law out there that says protect the union officials from going out there and making bomb threats. I think it's just another thing based upon fear, and it's just confusing me. I think the unions need more laws to protect them, to help them protect the people, and less to protect the corporations.
I guess I'll ask a specific question based on Michael's opinion. Irwin actually said in his opening statement that this is a solution in search of a problem. And I think the caller says, I don't understand where this comes from. And I guess the question to you, Alex, is what specifics do you have? What activity would be prosecutable that currently isn't? And how many of those do we have? What examples, concrete examples? You characterized the testimony at the House Judiciary hearing as horrific. But specifically, what would this legislation do, and what would it allow law enforcement to do?
It would allow law enforcement and prosecutors to prosecute parties to a labor dispute if they harass, stalk, or make bomb threats. And the current crimes code includes a specific exemption that was added back in 1993 that says if you're a party to a labor dispute, you are exempted from prosecution for these crimes.
And are you seeing a high demand from the counties and from management and employees of management asking for this kind of prosecution? In other words, where is the energy coming from that you're asking for this change?
It's something that we have seen in Pennsylvania for a very long time, and as I said, it's something that for many businesses it's really a way of life. A lot of, and we talked about in Philadelphia, a lot of our members in Philadelphia would not even contemplate not hiring a union shop out of fear for the type of retribution that they might face if they decide to go to an open shop. And businesses should have the right to contract with whomever they like, regardless of their union status. And the company that we referenced earlier, this is a company that for a major construction project, rehabilitating a building in Philadelphia in not a great area, they decided to use a combination of union and non-union workers, and what they got for it was this campaign of harassment, just intended not only to intimidate the company themselves, but to make it clear to any business in Philadelphia and probably any business around Pennsylvania that you better think twice before you make a decision that is not consistent with the union objective of having a monopoly on work.
And I guess my question again is, what specifically happened? Are you referring to the Post brothers?
Yes.
So what specifically happened in that situation that otherwise, if this law goes away, this exemption goes away, would be prosecutable?
The Post brothers folks have very well documented, and it's been helpful for a lot of companies. We hear stories from them. We've heard stories. I'm sure my predecessors for decades have heard stories of the type of abuse that has been inflicted upon them. This company is kind of a unique situation because they've been very proactive, in taking pictures and filming these instances, so we can actually see what has probably been happening for a very long time, but actually see the type of abuse that they've had to deal with. Everything from blocking entrances and exits, and people standing taking pictures of the residents of the apartment buildings coming in and out wearing scary masks. The example of members of the union following one of the employees with her child to their sporting event. Again, are all these activities considered harassment and would be prosecutable if Representative Miller's law is passed? I don't know. That's not my job to say what activity constitutes harassment or stalking and what doesn't. My impression from watching some of these videos and hearing the testimony I'm not an attorney, and I wasn't there, but gosh, it sure seems to me that something not right, something illegal was happening and should be able to be prosecuted. It's not my judgment to say, and you look at pictures and you see videos, and maybe it constitutes harassment or stalking, maybe it doesn't, but the fact is, law enforcement and a judge, a prosecutor should be able to make that determination without being handcuffed by a law that has this exemption in it.
Right now, we know that it is not criminal conduct. And we know that because not just the law says so, but because at the very hearing at which the Post Brothers official, whoever she was, I don't know her name, forgive me, testified, she testified as well that there was nothing that was done that would have been prosecuted under this change in the law that wasn't prosecuted because of the law. That's real world, because that was protected conduct. Alex conveniently asserts to you and us that they advocate this legislation because of being even-handed, that it applies to employers and unions alike. But then he proceeds to give repeatedly only one example, and it's an example that he expands upon and expounds upon that would have you believe that somehow or another, and I'm quoting now, everybody knows, unquote, that all of this union intimidation takes place. I've represented unions longer than Alex has been alive. Much longer, in fact. I'm proud to say that I do. I am proud of every single one of my clients that I'm honored to represent, and I work with them closely and intimately. I have yet to run into the first union official that knowingly, willingly, and intentionally either engages in or directs others to engage in the untoward conduct of which Alex so freely speaks, which he candidly admits he hasn't seen, that he only saw someone's edited pictures and videos of at a hearing. What I do know beyond peradventure, is that the people I'm honored and privileged to represent don't stand for that conduct. They are the first people in line to prohibit it in every possible way they can. Now, what I do know as well is that employers do engage in conduct every day. True conduct that institutes violence on families, when people lose their jobs, when people are threatened with a plant closing and running away to another place, when people are faced with all manner of coercion and intimidation in exercising their federally protected rights. That's true and real violence, and I'm not talking about the other things like a strike in 1919 in Homestead, Pennsylvania, where the Pinkertons came out and where the militia shot and killed people who had the temerity to suggest that they maybe should be paid a fair wage for their work. Or in the northeastern part of the state where men were hung because they were claimed to be Molly Maguires and framed for their activities in the mines of another era. We're not talking about that. That's not the issue. What is the issue is exactly what Alex ultimately, in his last interchange with you, discussed. We have 67 counties and 67 different DAs and 67 different judiciaries in this state alone. And at best, what we could hope for with this radical change in the law would be chaos. And it's unfair and indeed, I believe, disingenuous to suggest that this is somehow confusing law enforcement and criminal codes with labor management relations. There was a recognition by our General Assembly in 1993 that was simply supportive of the recognition of the Congress of the United States of America going back to 1935, that at some juncture there is an intersection between criminal codes and labor management relations, and the Congress determined that labor management relations and federal labor policy were such that they had to, as you indicated, preempt and occupy the field so that no state would do these kinds of things and create this kind of chaos.
But most states do not have these exemptions. So and
it's great that Pennsylvania happens to be first in something.
And we don't hear from, you know, I certainly don't hear from other states that this is a massive problem of inconsistency between federal and state laws. The federal law protects lawful unions and union members from exercising their right, but most states have not said, we're also going to give you a pass on harassment, stalking, and bomb threats.
Let's head back to the phones. Jeff from Pittsburgh, welcome to PCN.
Analysts, and thank you for taking the time to humor me. I have a couple of points I would like to make and then a question that I would like to direct to the panelists this evening. First point, 1993 was the first time in several decades that the majority of both chambers of the state legislature, as well as the governor's office, were occupied by Democrats. So for Mr. Aronson to insinuate the insertion of these exemptions were done in some kind of bipartisan kumbaya fashion and serves the best interests of Pennsylvanians as a whole is disingenuous at best. These are blatant carve-outs to serve a special interest group which has an extremely powerful lobby in Harrisburg and a stranglehold on Democratic legislators. Also, for Mr. Aronson to decry and invalidate the testimony which was received by the House Judiciary Committee simply because the testifiers didn't place their hand on a Bible, which is a bygone procedural technicality in Pennsylvania, as he previously stated, is a slap in the face to the individuals who came to testify. If I read the news reports correctly, the Chamber of Business and Industry and the House Judiciary Committee had a difficult time finding testifiers for that hearing simply because people were afraid to come in and testify. The removal of both these exemptions would have both parties of a labor dispute, employers and union employees. It would hold them equally under the law. If unionized employees are the peaceful, law-abiding citizens, which Mr. Aronson assures us they are, and he categorically opposes stalking, harassment, and threatening to use weapons of mass destruction, maybe he could enlighten the viewers tonight why the playing field needs to be leveled and what good these gross exemptions do anyone. Why don't other states issue these same protections? And I'll hang up and listen. Thanks.
Well, let's deal with a few things. First of all, other states do offer these and more protections, and some of them are even so-called right-to-work states, like the state of Nevada, where negotiating a collective bargaining agreement that results, among other things, in a union shop is not permitted. Has almost identical legislative frameworks to what we have here in Pennsylvania on this topic. More significantly, the suggestion that I'm being disingenuous about describing what happened in 1993 is itself rather offensive. Representative Jerry Bermelin, a Republican of Pike County, is the individual who introduced the amendment into the anti-stalking statute when it was being considered. Later, that was further refined by the Senate Judiciary Committee. The Good Representatives Amendment spoke in terms of it not applying to any federally protected conduct, and the Senate modified that slightly to simply say that it had to do with only labor disputes, as that term is defined in the Pennsylvania Anti-Labor Injunction Law of 1937. So he narrowed it further, the Senate Judiciary Committee narrowed it further from what Republican Representative Bermelin from Pike County, or Wayne County actually, had provided. In the last analysis, what we have here is elegantly simple. Under the guise of protecting people from putative harassment, alleged stalking, and this bizarre one that I keep on hearing about, terroristic threats or bomb threats, that is most bizarre because that, of course, is itself federally prohibited conduct and is prosecutable as a federal offense where there's a true terroristic threat. What we have is, under the guise of criminal law, an effort to further weaken the federal statutory framework, which is a policy that supports collective bargaining. Let me offer up one simple statistic. The National Labor Relations Board, which is the federal agency that administers the National Labor Relations Act, hears complaints about unfair labor practices by employers and unfair labor practices by unions. violations of the law that include things like firing or threatening to fire people because they exercise their rights, that include all manner of impermissible kinds of conduct by unions as well, between Section 8A of that law and Section 8B of that law. 89.1% of the unfair labor practice charges prosecuted by the National Labor Relations Board are against employers, and roughly 9.1 or 2% are prosecuted against unions. Overwhelming evidence of what is really going on. And even in the face of that statistic, in the face of that fact, what we have is a desire to further tip the balance against workers who exercise their federally protected rights. And that's truly what this is about.
Well, I guess a couple points. First, on the last statistic with the National Labor Relations Board, just to provide some context. If you have a small or a medium-sized business that has a union organizing campaign happening in their facility, in many cases, these are, especially the small business owners, these are not experts in labor law. They do not have, the ability or the money to keep lawyers on retainer to track activity. So yeah, oftentimes they might not even know that it's really an option to file a complaint with the National Labor Relations Board when there's some type of activity occurring that they think is unfair. On the other hand, unions have armies of lawyers who do nothing but file unfair labor practice violations or motions with the National Labor Relations Board, and that's all they do all day. I don't think it should be surprising at all that
and
the
that's
numbers,
based on your experience as well?
That the numbers,
the reality is that any corporation, any major corporation in this country has more lawyers at its disposal on a regularized basis than the entirety of the labor movement that I wanted to represent.
You're talking about major corporations, but as you know, especially as the number of unions, the number of union members in the country and in Pennsylvania has precipitously declined in recent decades. You find unions more and more are looking at small businesses, medium-sized businesses to expand their ranks. And yes, these individuals, these small businesses, do not have lawyers at their disposal.
Unions don't look to expand their ranks. Workers reach out to unions to get the protection of a collective bargaining agreement. Indeed, the caller that prompted this exchange between us talked about how tough it was to get witnesses to come to that House Judiciary Committee hearing. Do you know how many union opponent testimony offerers were at that hearing, counting all of them? There was one. There were a total.
Do you know how many were invited?
There were a total of 9 or 10 witnesses that appeared, and exactly one was Secretary Treasurer Frank Snyder of the Pennsylvania AFL-CIO.
And that came up during the hearing, and the chairman of the committee very quickly said, we invited a whole host of unions to present testimony at the hearing, and only one responded.
And
I personally went to the chairman.
I know that representation was made, but I didn't see any of them. I only saw one other invitation, and I'm privileged to represent a whole lot of unions.
Let's head back to the phones. Carrie from Beaver, welcome.
Oh, hi, yes. My comments are basically directed to Mr. Halper. I understand currently there is a lot of anti-union mentality out there. However, I have been a union rep for over a decade. We've had organized rallies, marches, attendance in government meetings, which were all held as peaceful demonstrations. No police interventions were requested or needed. Our public events are to raise awareness within the community. We are not creating riots, turning over cars, or doing any of the things portrayed in movies from years ago. We're healthcare workers, teachers, social workers, community liaisons. I'm proud to be friends with the steel workers, carpenters, electrical workers, all of them. Most of them I know will give you the shirt off their back. So I'm not quite sure what the portrayal is regarding the anti-union message that's being out there. And Mr. Halper continuously states regarding all of these bad union people. However, I haven't heard him say what percentage of this actual occurrence is being created, because he just consistently says it's union workers and these union workers and those union workers, but I haven't heard a percentage of union workers that he is stating is creating this havoc.
The caller should be very comforted to know that Representative Miller's legislation will not impact you. You know, based on your description of your activity as a union representative, you're going about it the right way, and you ought to have the ability to stage rallies, to stage protests, as long as they're done legally within the confines of the law, consistent with all the protections that are afforded to you as a union from both the federal and the state government. You've got nothing to worry about. As I said, it is what I think is probably a small minority of the organized labor community that we are talking about when we're discussing this legislation, when we're talking about exemptions to the crimes code. So I think the caller this legislation is not going to impact her and other union members like her.
Alex, we can't have it both ways. On the one hand, you tell us a few minutes ago that this notion about what is harassment, what is stalking, is a gray area that is not something that you, sitting here tonight, are capable of discerning, and that you want to leave it to law enforcement. Yet you tell this caller, this nice person, this honest person of great integrity, who gets up enough courage to call this program and face off with you, that she has nothing to worry about. Now, you can't have it both ways, buddy. I respect your notion that it's a gray area. I candidly agree with you that it is a gray area, and that's precisely what we find so scary and so fundamentally subject to concern, because it destroys the predictability that your business members have about how this process is going to work. But you cannot tell us tonight both that it's a gray area and then categorically tell this caller that she has nothing to worry about. Are you special that you can do that and none of the rest of us can?
Well, I'm not sure how much courage it takes to take me on, but you know, I think anyone.
Listen, they had to dust me off and bring me up just to be here with you tonight.
But you know, I stand by what I said. I think any attorney, anyone in the judiciary would say that a crime like harassment, the context is important, and I think that if there is an employer who takes what the caller, the situation that the caller described, and goes to a judge and says, we're being harassed, these unions are protesting, I think I would suspect, I don't know, but I would suspect the judge would tell them, this is not a legitimate case you're bringing against me.
But the problem in our system is it's an adversarial system.
So why don't
before it gets to a judge, we have a district attorney, and we have possibly an indicting grand jury, and we have an extraordinary amount of public attention, public expense, taxpayer dollars invested in this, only to get to a point where a judge or a jury makes a final determination. By that time, there have been at least 2 or 3 lawyers involved. There has been a law enforcement community involved. And of course, we're in a situation where all of our local governments are having to make very tough choices about how to allocate their resources, because money is tight. Money is tough. Taxpayers are already overburdened, and you're advocating adding another unfunded mandate to the process of criminal conduct.
I appreciate your concern over local government budget situations. I think that every other person, every other situation in Pennsylvania, someone has a right to say that I'm being harassed. I want my law enforcement to do something about it, and I simply don't see why the labor community and why a labor dispute should be exempted from that.
And with that, we're out of time. Irwin Aronson, Labor and Employment Attorney for Willig, Williams, and Davidson, thank you.
Thank you.
And Alex Halper, Director of Government Affairs for the Pennsylvania Chamber of Business and Industry, thank you as well.
Thank you.
Coming up next on the issues with Chief Justice of the Pennsylvania Supreme Court, Ronald Castile. He's running for retention in next month's election. Watch tonight at 8 p.m. And if you didn't have a chance to call in and comment during tonight's show, you can weigh in on our website at PCNTV.com. I'm Corinna Wilson, and for everyone here at PCN, thanks for watching.